is available on YouTube, Northumberland TV. Members are asked to keep the mics on mute until you speak. The procedure is we'll go through record of attendance, minutes of the previous meetings, then we'll hear the applications. Public speaking will follow the outline of the application from the officer. Objectors will have up to 5 minutes, local members or parish councillors will have up to 5 minutes, and supporters will have up to 5 minutes. Members, no questions in relation to written representations of or by local members. We'll then have committee members' questions to the planning officers, followed by a debate where we'll be looking for a proposer and a seconder for whatever motion. We'll have a show of hands to record the vote. And if there is a dead heat, then the chair has the casting vote. So, straight on to the meeting. Apologies for absence. Have we got any apologies?
I've received apologies from Councillor Thorne.
Any from the floor? Everybody looks to be here. Thank you. Minutes of the previous meetings. Now we've got 2. Do you want me to do these singly or will you accept them together? Has anybody got any questions on either of them? Can we accept them for the 3rd of August and the 7th of September then, please? Thank you. Cracking on. Disclosure of members' interests. Any members got interest in tonight's agenda? Can't see any. Thank you. Right, determination of planning applications. What I've agreed to do is change the running order. So the last application, number 8, will become the first one we hear because of the amount of public speakers. So we'll crack on with that one, which is a variation of condition 15 of Planning Permission 20/03342/Vary Code to amend construction delivery hours in respect of development for 285 dwellings with associated infrastructure and landscaping, land northeast of New Hartley, St Michael's Avenue, New Hartley, Northumberland. And I think, Jeff, you're the officer.
Okay, thank you, Chair. Okay, if we can just start the presentation this afternoon, just with a quick overview of the site itself. So you've got the location plan there showing the application site. The site is essentially the purple-coloured hatched sort of area in the centre of the plan. As I say, the pink-coloured area on the right-hand side is essentially the Seaton Delville Hall conservation area. So the site lies just to the immediate west of that, on the northeastern edge of New Hartley sort of village. Just by way of background in terms of the development of the site. Planning permission was granted on appeal in September 2017 for 285 sort of dwellings on the sort of site. There have been a couple of subsequent variations of that 2017 planning permission since the appeal sort of hearing. So those were approved by ourselves in March 2019 and April of this year. The number of dwellings, however, remains the same at 285. The slide on the screen in front of you there, that's the latest approved site sort of layout. Just some sort of photographs of the site, just to give you a flavour of the situation on the ground. Construction work started on site around about 12 months ago in the autumn of sort of 2020. So has been progressing since then. So you've got just some photographs here of the present situation at site. So a view there of the main site access from St Michael's Avenue. Just some further views up St Michael's Avenue, which is the main site frontage, the one looking east along St Michael's Avenue. So that's looking out of the village towards the open countryside and the conservation area. And then a photograph looking in the opposite direction, so looking west now from the in towards the sort of village from the open sort of countryside. So you can see from the photographs there that the dwellings, construction of dwellings along the main road frontage is quite well advanced at this particular point in time. Just a few from the site access there, looking into the site itself, just gives you an idea of the entrance into the site. And then just another few there in the opposite direction, looking out of the site access onto St Michael's Avenue itself. So just moving on to the proposal. As your report outlines, the application is a submission under Section 73 of the Town and Country Planning Act to vary one of the conditions on the existing most recent planning permission for the site. The condition which the applicant is seeking to vary is condition 15, which relates to construction activities. Essentially, as worded at the moment, you've got the existing wording there on the screen of that condition. So that condition at the moment essentially says that construction activities need to be undertaken in accordance with a construction method statement and other construction work mitigation details that were approved earlier this year in March 2021. The applicant wishes to amend the wording of that condition to essentially allow them to have extended construction delivery hours. The currently approved construction delivery hours are 9:30 a.m. until 4:30 p.m. Monday to Friday, and the applicant wishes to extend those delivery hours from 8 a.m. to 6 p.m. again Monday to Friday. There will be no weekend or bank holiday deliveries, so its proposal is 8 a.m. to 6 p.m. Monday to Friday. None of the other agreed construction management details changed from what was approved back in March of this year. So, for example, one of the other details that was agreed was a route for construction vehicles, which essentially avoids construction vehicles travelling through the village. They come into the site via another route into the village, which essentially is largely open countryside. So in terms of the revised wording of the condition, there is some change to the proposed revised wording from what was in your report. I think you've all been given a separate sheet of paper on that. It's also on the screen in front of you. Essentially, I've highlighted the changes on your sheet of paper from what's in your report. So those changes, essentially two changes from the wording in your report in terms of the wording of the condition. First of all, after the 8 a.m. to 6 p.m. Monday to Friday, we've just emphasised that obviously that does exclude bank holidays, so there won't be any deliveries at all on bank holidays. And then some text has been added on to the wording of the condition, which essentially just re-emphasises this point around that no construction delivery vehicles should be accessing the site through the village. That route is secured at the moment through what was approved in March 2021. There is a signage plan that was approved earlier this year, which clearly defines the route for construction vehicles with signage in various places to make sure that drivers of delivery vehicles are directed down the appropriate routes. There's just some examples in terms of photographs. So that's one of the signs in the centre of Seaton Delaval, which is one of the neighbouring villages, which directs delivery drivers down the countryside route rather than through New Hartley village. And then another sign there again, that's on the avenue just between Seaton Sluice and Seaton Delaval, which again directs traffic along the agreed sort of route rather than heading into the village or built up area before they get to the site. So, as I say, the wording's been added just to really emphasise that point, which obviously it's more important if the hours are extended that, that as I say, there is adherence to that sort of construction vehicle delivery route if there are going to be construction vehicles entering the village earlier in the morning than is the case at present. So just very quickly summarising, as I say, consultation responses. You'll see from your report that there is an objection to the application from Seaton Valley Council. There's also an objection from Councillor Ferguson, who is the ward member for Hartley Ward, within which the application site sort of lies, and also a further 22 letters of objection from local sort of residents. You'll also see from your report that there are no objections to the proposal from the County Council's Highways team, Public Protection team and Network Rail also have raised no objections. That's in relation to the fact that there is a level crossing quite close to the site, so they're not raising any objections from that kind of standpoint. There are no changes to your report in terms of representations this evening. We've not had any further representation since the report was finalised. So just very quickly in terms of key sort of issues for consideration. As I say, there are no changes at all to the actual development itself in terms of the number of houses or the layout or the design of the houses. So that very much remains as per the most recent planning approval of April sort of 2021. So in terms of all of those issues around, as I say, the principle of the development, the housing mix, affordable housing, impact on the character of the area, site layout design, the access, flooding, drainage, contamination, ground stability, ecology, nothing changes. So the proposal is still considered to be acceptable in those respects. The two key issues, therefore, that as members you need to consider this afternoon are essentially the additional issues arising from altering the construction vehicle delivery hours. So essentially you're looking at two issues. One is residential amenity and the other is highway safety, and the judgment you need to come to is essentially what your views are on those matters arising out of the increase in the construction delivery vehicle hours. As I say, in terms of turning firstly to kind of residential amenity impacts arising from that change in delivery hours, as I've just advised, the Council's Public Protection team don't raise any objections on residential amenity grounds to the additional delivery sort of hours. Overall, the view of officers, as detailed in your report, is that significant additional harm to residential amenity would not arise by increasing the delivery hours, bearing in mind that construction works can already take place on the site between 8 AM and 6 PM. So essentially, the proposal will just bring the construction delivery hours in line with the construction working hours that are already permitted on the sort of site. And also in bearing in mind, as I say, the construction delivery vehicle route that has been agreed, that results in, as I say, essentially construction vehicles having to come to the site via a country road that doesn't involve coming through the village. So again, bearing that in mind, it's not considered that significant additional harm would arise to amenity from the amended hours. Coming on to highway safety, again, just to reiterate what I said earlier, that the Council's highways team don't raise any objection to the change in hours from a highway safety point of view, and Network Rail have no objections in terms of impact on the nearby level crossing. You'll see from your report that the current delivery hours, the 9:30 to 4:30 hours, those were suggested by the applicants themselves at the public inquiry. So that's where those come from when we had the planning appeal. However, that doesn't necessarily follow that that the revised hours that are now proposed are unacceptable. At the end of the day, as members, you need to assess the revised hours that are being proposed on their merits, as I say, having regard to the residential amenity and highway safety issues. The Councillors Highway Authority do acknowledge that increasing the delivery vehicle hours will result in construction traffic visiting the site at peak times in the morning, which, as I say, isn't permitted at the moment. However, that needs to be offset against other considerations. There are potential benefits that arise from changing the delivery hours to allow those to take place from 8 o'clock. So essentially those include, for example, spreading out deliveries to a greater extent in the morning period. It also potentially reduces the likelihood of a particular issue that has arisen over the last year or so, where you'll get delivery vehicles queuing up outside of the site before 9:30 in the morning, obviously waiting to sort of get in, and that has been the source of some complaints from residents of HGVs parking on St Michael's Avenue outside of the site, arriving early and then having to wait outside until 9:30 when they're allowed into the site. You'll see from your report that some of the objections refer to breaches of the current restrictions having taken place around the delivery times, and also around vehicles coming into the village through the village to make their deliveries rather than using the agreed sort of route. There have been some breaches of the conditions, although, as I say, investigations undertaken to date by our planning enforcement team. The view is that those are very much the exception rather than the rule. Generally, as I say, the conditions are, in the main, in our opinion, being complied sort of with, and Barrett Homes, as the developer, have been endeavouring to liaise with their suppliers to ensure that delivery drivers adhere to sort of the rules. As I say, signage has been erected. I showed you some of the photographs of that, and there is also, with this particular site, a liaison group in place which meets on a regular basis, which involves Barrett Homes, the local residents, Seaton Valley Council, and officers from the County Council. The purpose of that liaison group being to try and iron out quickly any concerns that that residents have about the sort of scheme as it progresses. So that's just a very quick overview of the issue. So the recommendation, just moving to the recommendation, it is, as per your report, that the planning permission be granted subject to the conditions as detailed in your report, but with the changed, the amended wording to condition 15, which is on the separate sheet that you've been given at the start of the meeting. Thank you, Chair.
Thank you, Jeff. I didn't ask us, all members had copies of the photographs and seen the video of everything on the agenda tonight, what we've got. Good. Right, public speaking. The first one, objector, Mr. Barrell. Have we got Mr. Barrell here? Remember the, yes, your speaker. Thank you. You've got 5 minutes.
Thank you, Chair. Let's be honest, the planning system is broken. Builders appear to do what they like without penalty. The issue of construction traffic was first raised in 2015. Then Network Rail were assured that a construction management plan would be agreed before work started, detailing the number and type of vehicles and hours of operation. It didn't. But it is the construction management plan that is the condition. Delivery times are just one aspect. Delivery hours were discussed and agreed before the planning inspector in 2017 to mitigate the numerous concerns raised, not just by Network Rail, that a development of 285 houses would have on a small isolated village with only one road. It wasn't that heavy vehicles would pass a local school, but they would increase traffic on the only road into the village. The case presented included an analysis of delivery times, demonstrating only one wagon an hour between 9:30 and 4:30. Now, residents repeatedly submit evidence that in excess of 4 wagons are entering and leaving before 9 a.m, as supported by Barratt's own evidence to this application. That report also states that there is no school nearby. New Hartley First School is only 500 metres from the site, and children walk or are driven there. Similarly, to access the middle school in Seaton Sluice and the middle and high school in Seaton Delaval, children and parents walk, cycle or are driven along that single road, as well as increasing numbers of commuters. That's a lot of people moving along a road when large wagons may be coming and going. The location of New Hartley and its restricted road network cannot be shoehorned into a one-size-fits-all argument that all sites operate delivery hours starting at 8 a.m. Everyone agrees that the designated route is not wide enough in places for 2 wagons to pass without mounting the only footway between New Hartley and Seaton Sluice, that at that point is unlit. Every day, 3 coaches transfer children to and from Seaton Sluice along that road. The restriction in hours was to remove any risk during these times. Barratt's own highway expert said that deliveries would be limited to avoid peak traffic hours and that all construction traffic would enter and leave via the avenue, therefore avoiding the greatest part of the village. Over 7 years, you'd think an experienced developer like Barratt would have ample time to implement the obligations of a requirement they themselves proposed. Yet 2 months after final approval of the condition, the applicant is back seeking yet more changes. Why? The answer's simple. Since construction began in October 2020, without the necessary conditions being in place, Barratt's have blatantly and continually breached their own restrictions and are being threatened with enforcement penalties for non-compliance. Residents have had to put up with workers arriving on site from 7 a.m, commencing work shortly thereafter. We're continually reporting deliveries arriving early and using the incorrect route. Sometimes they're allowed straight in, sometimes they're turned away. Sometimes they park opposite the site, causing visibility and congestion problems. The construction management plan also stated that Barratt's would monitor compliance and work with the supply chain and local residents to resolve any problems throughout the entirety of the development. Regular liaison meetings repeatedly identify these issues, and we are promised that suppliers will be reminded about the restricted hours. Yet nearly a year on, they are still being flouted, and the same companies still deliver how and when they please. The variation to delivery times is to facilitate the building's timescale. Does nothing for the health and well-being of local residents. Work on site regularly ceases around 4 p.m. when they can work until 6. So progress could be maintained simply by starting and finishing later with no impact on current delivery times. The only work that is on programme is house completions. Even so, new residents this month will not only have to contend with living on a building site, but lack of mains drainage. Yet another pre-construction condition that is incomplete. Residents can see no justification in anything Barratt's request to warrant changing the delivery times. With good management and working in line with these conditions, this site can be delivered on time. We request that this variation is refused, therefore ensuring safety and well-being for everyone.
John, is that it?
Yeah.
Thank you. We've had it 5 minutes. We're now going to go to the elected members, and I'll call on David Ferguson first and Graham Eastwood second. So, David, you're doing 2.5 minutes, I believe.
Thank you, Chair. So, since January 2021, 15 meetings have taken place between the residents and Barratt's homes. At every single one of these meetings, issues have been raised regarding deliveries taking place prior to the 9:30 a.m. agreement and construction traffic not following the agreed route, instead coming through the village itself. Logs have been kept and the information shared, but no discernible improvement has been seen. If the committee approve the application, it is clear from our past experience that they will be allowing heavy construction traffic to travel through the village at the times when children are travelling to school. Section 3 of the Council Corporate Plan states, we want to ensure that positive choices are easy to make, that being out in your village, town or community is safe and welcoming, that you can enjoy walking and cycling to get from A to B. A scheme is currently being implemented at New Hartley First School to encourage more cycling and walking to school in line with the Council's priorities. The details of this scheme involve stopping traffic from driving up to the school. Instead, the traffic will be encouraged to park at the Memorial Hall or Social Club and for the children to walk to school from there. This involves crossing the main road through the village. The plans indicate a safe crossing is to be installed on Bristol Street, but this is not yet in place. For this scheme and the section of the corporate plan are quoted cannot be delivered with construction traffic driving through the village of New Hartley. A similar scheme is underway for Seton Sluice Middle School, which again is attended by children from New Hartley. However, the walking and cycling route for these pupils take them along St Michael's Avenue, which is the agreed route for construction traffic. Those who use this route regularly know that it is not wide enough. Buses mounting the pavement to pass other large vehicles is a common occurrence, and allowing construction traffic to travel this preferred route at peak times would further endanger pedestrians. Furthermore, the section of this road and footpath is unlit. Paragraph 111 of the NPPF states that planning permission should be refused where there would be an unacceptable impact on highway safety. Residents accept that the development is taking place and will likely be as happy as anyone else to see it completed. However, until Barrett's can provide evidence of ongoing compliance with the current terms which prevent traffic travelling through the village, there is too great a risk to the residents of New Hartley to have construction traffic and school traffic mixing. Even with construction traffic following the accepted route, the risk is arguably still too great. Approving this proposal sends the message that the needs of a house builder outweigh the need for school children to be able to walk to school in relative safety. Thank you, Chair.
Thank you for that, David. Mr Eastwood.
Thank you, Chair. Graham Eastwood on behalf of Seton Valley Council. Members will have read in the committee report that many valid concerns have been expressed by the local community in response to this application. As far as Seton Valley Council are concerned, the two main planning issues are that the applicant has not demonstrated that the proposed change to the delivery hours would not have an unacceptable impact on the highway safety and severe impacts of the road network. And secondly, that the local residents, particularly those walking to school that have been identified already, would be put at risk from harm from air pollution as a result of an increase in the traffic from the deliveries around these particular times. With regard to the first issue of highway safety, it is a material planning consideration in the determination of this application that as part of the public inquiry into the development, the applicant themselves proposed that the delivery hours would avoid peak times. This element of the proposal formed the inspector's decision is the overall impact of the development. 8 o'clock to 9:30 is and are peak hours. As far as the routing of the transport, that's not happening. Those signages are being ignored. There are still vehicles coming through the village of New Hartley, passing the school, passing the houses, and passing people walking their children to school. The exception, some might say, is, in our view, a clear breach of the case that was put to the public inquiry. Both the current and emerging development plan policies are clear that planning permission for new development will not be granted unless it has been demonstrated that it can provide safe and efficient access. Without the evidence, there is a clear conflict with policy DC 11 of the Blythe Valley Development Control Policies document and the emerging Northumberland Local Plan Policy TRA 2. Furthermore, paragraph 111 of the NPPF states that planning permission should be refused where there would be an unacceptable impact on highway safety or where the cumulative impacts on the road network would be severe. This is clearly the case. If the application is approved, this will result in an increase in traffic at the busiest point of the day, where people are travelling to work and parents and children are travelling to school. Seton Valley Council have significant
can you wind it up in
concerns.
10 seconds or so?
Very difficult, but I will say that are further references to the development plan and the Northumberland local plan. What I would say is that Seton Valley endorses the views of the residents but we urge the members to refuse this application in accordance with the development plan to protect the health, safety and welfare of our community. Thank you, Chair.
Thank you. Now then, have I got two supporters? I've got Stephen Wooldridge and Nick Bunn. Yes, I've got the two, right. So, Stephen, would you like to go first for your 2.5 minutes? Are you splitting it?
I'll go with Nick first, if that's okay, please.
Go, Nick. Okay, Nick.
Press something. Right. Good afternoon, and I hope you can all hear me. My name is Dr. Nicholas Reynolds Bunn. I'm a director with Tetra Tech. I've been employed by Barratt Homes as an independent highways consultant to review the suitability of the request for extending the construction delivery hours from a highways point of view. Barratt originally stated in their construction method statement that delivery times would be restricted from 9:30 a.m. to 4:30 p.m, although this was not a requirement from the either the appeal decision nor the planning condition which the inspector stipulated. It wasn't anticipated at the time, but it has become apparent that the restricted delivery hours have caused some problems in terms of the construction efficiency on the site and also congestion on St Michael's Way. The proposed alterations and delivery time seek to address these problems. In relation to congestion, this is in the mornings on St Michael's Way before 9:30 a.m. It results from lorries arriving at the site prior to 9:30 a.m. They're not permitted entry and then wait on St Michael's Way for the site to open and allow them to enter. The number of lorries waiting varies from day to day, but it can go as high as 5 vehicles waiting 10 to 15 minutes. The waiting lorries are an inconvenience to other road users on St Michael's Way as they seek to pass. Extending the delivery hours to align with normal construction periods and with the on-site working hours will mean that lorries can enter the site on arrival without the need to wait on the highway, and so removing the need for other road users to pass waiting lorries. This will reduce the inconvenience to other road users and is the main highway benefit of the proposal. Because the number of deliveries per day is not expected to increase, but the delivery window will increase from 7 hours to 10 hours a day, then on average the hourly delivery frequency will reduce from 2.3 to 1.6 lorries per hour. The reduction in the average hourly frequency will also benefit the local road network and reduce the risk of on-site congestion. In conclusion, the proposal to increase the delivery times to between 8 a.m. and 6 p.m. will improve local highway conditions by reducing congestion on St Michael's Way, resulting from lorries waiting to enter the site, will reduce the average hourly number of lorry movements on the road network and reduce the on-site congestion. The 9:30 to 4:30 p.m. delivery hours restriction was not required in planning condition 15 nor in the appeal decision. There's no
Nick, you've had
reason in highway
2.5
terms
minutes if you're going to split it equally.
Yeah. Thank you. Thank you, Chair. My name's Steve Wooldridge. I'm Technical Director at Barratt David Wilson Homes North East. You've heard from our highways consultant, Dr Nick Bunn, that there are no technical reasons precluding our desire to extend construction delivery hours on the site at New Hartley. However, I'd just like to take a moment of your time to explain the importance of this request for the delivery of the development and link to this, more importantly, for the economic recovery within the North East of England. The current delivery hours are impeding the delivery of houses on the development. It's imperative for a site to operate efficiently that materials, timber kits, precast floor cassettes, etc. are delivered at the start of the working day, i.e. 8 a.m, on site to ensure a full and productive day of build. As most of you will be aware, it's increasingly difficult to find sufficient construction workers when sufficient materials are not available on site to allow them to work. Their earning potential drops. This is not a good situation for the local workers who rely on this and simply means construction will actually take longer on site than anticipated. The site is being constructed using timber frame, a sustainable method of construction, but one where the kits are delivered on a just-in-time basis to be constructed that day. So it's imperative that they can be delivered early on in the day, especially as we are now losing the evening light. In making this request to extend delivery hours, the applicant would hope that County Council recognises the opportunity it can play in supporting economic recovery and the government's commitment to deliver 300,000 new homes a year by the middle of the decade. The extra 3 hours a day is immaterial, and as our highways consultant and NCC's highways team recognise, there are actually benefits to the network from utilising these hours. Balanced against this, I would ask the committee to recognise the benefits of Barratt David Wilson delivering much needed new houses across Northumberland, the wider economic recovery in the North East and continuity of construction jobs and labour on site. Further still, the benefit to the village of New Hartley as we deliver well-designed homes giving an enhanced feel to the entrance of the village, new residents to enhance the community and driving the local economy.
Thank you. Right. Members' questions to the officer. Georgina.
Thank you. Don't know where to start. Can I ask, what exactly is happening with from an enforcement point of view? Because we've heard representation that Barratt are breaching current rules about when the vehicle deliveries, and that they 1 lorry an hour and it's 4 and so on. So from enforcement's point of view, what data can you provide to us about what's actually currently happening at the moment?
Yeah. As I say, there is monitoring of the site being undertaken by our enforcement sort of officer. That's basically a combination of the enforcement officer visiting the site on occasions to observe what's going on. We've also asked basically residents to supply logs of what's going on. There isn't a consistent pattern in terms of numbers, in terms of breaches taking place. What we've tended to find over the last sort of well, during the course of this year is that that there may be some days or weeks when, as I say, the breaches are more substantial than others. It's difficult to pin down precise sort of figures in terms of breaches that are happening on a regular sort of basis, other than to say, as I said earlier, that overall, I think our general view is that the number of breaches compared to the number of vehicle movements is small scale. So we're talking about very small sort of numbers of sort of breaches, but there have been times over the last over the course of the year where, as I say, that there's been a greater intensity of breaches than at other times. As I say, when those concerns have been sort of raised around sort of breaches, as I say, we have this liaison group in place which was meeting on a fortnightly sort of basis. More recently, that's gone to sort of meeting on a monthly basis. So essentially, concerns are discussed at that liaison group meeting, and then sort of Barratt's take away those concerns and essentially seek to address those concerns. And during the course of the year, measures have been put in place to try and address, as I say, the concerns that have been raised around sort of breaches. So, as I say, I mentioned around, obviously, Barratt's having had conversations with their suppliers. We've got to the situation more recently because of, obviously, the continued concerns around occasional sort of breaches, where Barratt's now are basically printing notes on all of their delivery paperwork that goes out to suppliers, again emphasising that this particular route into the village that avoids going through the actual village itself does need to be adhered to. There've also been measures put in place in terms of the site itself. I did show you on obviously the signage I mentioned in and around the locality to direct vehicles. In terms of the site itself, in one of the photographs that I showed, that one there, so you can see that that's the exit from the site. So again, there's signage at the exit from the site that clearly directs drivers to turn left out of the site, which takes them down the countryside route that they should be using, and not right into and through the village when they're leaving the site. In terms of the issues around sort of delivery drivers arriving sort of early again, the site has been gated and manned essentially to stop sort of construction vehicles coming into the site before sort of 9:30 in the morning. That's, as I say, a more recent work that's been undertaken because vehicles were coming into the site on occasions earlier than sort of 9:30. So that's very much the situation. It is a fluid situation that we've found has changed from week to week throughout the sort of year, and both through the liaison group and then through Barrett's themselves, obviously efforts have been made to secure adherence. Obviously, one of the difficulties when you're dealing with suppliers who obviously aren't directly employed sort of by Barrett's, we're talking about drivers here who are working for other companies, is that yes, you can speak to the suppliers, you can put notes on the delivery paperwork, but you're always reliant. You can put signage up, but you're always going to be reliant to a certain extent on drivers obviously adhering to those sort of rules. So a lot has been done to secure compliance, and I think our overall picture is that in the main the conditions are being complied with. Yes, we acknowledge that there are occasions when that is not sort of happening, but as I say, in the majority of cases, I think our view as officers would be that there is compliance.
I mean, Chair, through you, I mean, the first speaker, and this is something I feel strongly about, and it's a general point as well as relevant to this application, mentioned about this perception of developers making breaches and getting away with it. And I think this sort of line of sort of conversation is, yes, they're breaching it, but we're not doing too much. They're getting away with it. I mean, that's what it sounds like. I mean, we've got a situation where, you know, presenting an independent consultant, independent employed by them, we've got, you know, them holding on to the thought about housing delivery. Well, never mind the fact all these developers are sitting on land and drip feeding the market, and then they're saying, you know, it's other factors that are holding up the delivery of housing. I mean, you've said, just to follow up on the question, you've said that the breaches to this, are we saying that breaches and extended earlier times coinciding with children going to school, are we saying that this isn't causing any problems at all? Which I would find very difficult to believe.
Well, I think with planning enforcement, there is an element of judgment. As I say, the taking of formal action is obviously at the discretion of the county council, and in deciding whether or not to take formal action around sort of breaches, we do have to look at the, as I say, the frequency of those breaches and the level of harm that they're sort of causing. As I say, if we're in the situation where we take formal action, say a notice is served, and there continues to be a breach of that sort of notice, then essentially we're going to be in a court sort of situation. So we, as a local authority, have to be able to demonstrate that any action that we've taken is proportionate and reasonable. So even though there may be a technical sort of breach, we still have to demonstrate that, as I say, the action we're taking is reasonable, and we're not being unreasonable in terms of any action that we're taking. As I say, the few to date of officers from monitoring that's been undertaken is that, yes, we acknowledge that breaches are taking place, but our view as officers is that the extent of breaches taking place are not sufficiently substantial to warrant sort of formal enforcement action. That's the position we consider
Sorry,
ourselves
Chair,
to be in at the moment.
this is an important point. Can I just ask, just to wind it up, so if what I'm looking to get an understanding of is how much problem this is causing, and if, say, for example, if this did go through today, then there's a suggestion if they could start at 8 o'clock, they might start at 7 o'clock, and then if they get away with it, then they could start at 6 o'clock. So when are we going to get tough with this? And could you? And the other point is, I want to get an understanding, because this isn't a part of the world I know very well. What is actually happening, and what are the problems caused by? Because obviously, the fact that there was this time put in initially, it is a huge site in a village, so it needs to be managed. So, you know.
Well, in terms of harm sort of arising, clearly some harm arises if conditions are not adhered to. But as I say, that the judgment that, as I say, needs to be made at the end of the day in terms of formal action as to whether that harm is significant. If, for example, you've got a situation where, say, in the course of a week, there's only one vehicle that comes through the village rather than using the designated sort of route. I think our view as officers would be that it would be difficult in a court situation to demonstrate that that level of breach was causing significant sort of harm. There's also the flip side of the coin that's been mentioned, obviously, in my presentation and by Barrett's in their sort of representations, that that obviously there are some sort of issues at the moment arising out of the currently approved sort of delivery hours, and that because delivery vehicles are not allowed into the site until 9:30, that is resulting in a situation where you've got drivers who are turning up early at the site and having to queue on the public highway in front of the site, in front of people's houses. Now, obviously, we can't stop people parking on the public highway. There are no parking restrictions on St Michael's Avenue. But obviously, clearly, that is of concern at the moment to the residents who live on St Michael's Avenue, opposite the site. And as has been said, it is our view, as well as the view of Barrett's, that one of the benefits of allowing sort of the longer delivery hours will be to reduce the potential for that sort of queuing on St Michael's Avenue, as well as spreading out the deliveries to a greater extent than is the case at the moment.
Thank you, Chair. Councillor Stewart?
Thank you, Chair. A very specific point here. We've heard from the first objector there and the local member, both spoke well, and also the highways expert from the developer. It's in relation to the lorries mounting the pavement, so they can't cross. It's not wide enough there. That's a major concern, not just because of the cost and inconvenience, but the dangers to the public there as well. Is there anything within this applications which will stop that from happening in the future? And the other things you did mention there, sorry, Jeff, that there's no restrictions on parking outside. But surely, if it's not illegal to the Highways Act, surely we can put something in that in the planning conditions?
Right. We deal with the first question around the width of the highway. If I just go back to one of the slides that I shared sort of earlier. Sorry. Yes, this is the directional signage plan that I mentioned. Now, the issue around the width of the highway, that relates to the country road to the immediate west, sorry, the immediate east of the village and the site. So basically, when you turn left out of the site, you go across the level crossing on the Northumberland sort of line, sort of route, and you come on to this section of country road between the village and the A190, the avenue, which you probably know is the road that Seaton Delville Hall is on, between Seaton Delville and Seaton Sluice, that long straight sort of road. But so basically, where the road is substandard is this section of country road between the village and the A190. The avenue, where along a section of that road it isn't sufficiently wide to allow two large vehicles to pass one another if they're obviously approaching each other in opposite directions. There are proposals under the section. There is a Section 106 agreement which runs alongside the planning permission for the site, and essentially that provides for £162,000 contribution for some highway improvement works on roads within and just outside of the village. And in terms of this section of highway where you've got the narrow width, some of those monies will go towards providing a traffic calming feature in that location. So I think the thinking at the moment that the detailed design hasn't been agreed yet, though these various improvements need to be in place prior to the occupation of 70 open market dwellings out of the 285. That's what is in the Section 106 agreement that was agreed at appeal by the inspector. So essentially the traffic calming measures to address the road width, you can't widen the road, that's the difficulty, because there are, as I say, adjoining land ownerships that the applicant doesn't have, or the county council don't have control over. So essentially the proposal in the Section 106 agreement is to introduce basically a traffic calming feature whereby you'd essentially have a kind of give way type system. So vehicles coming in one direction would have priority over others to try and avoid this situation where you've got two large vehicles trying to pass each other at the same time and one of them having to mount the
Sorry,
pavement.
Jeff, sorry if I may interrupt. It's really the construction traffic I'm talking about now, rather than the future. So is there anything which the developer can do to make sure we haven't got vehicles coming opposite directions and going on the pavement at this time? Get the future.
Not in the short term, no. As I say, there is a proposal in terms of the 106 agreement, as I say, for this traffic calming feature, but that won't be in place until at least 70.
Rob Murphy. Through the chair, can I just add that it is public highway at that point, so controls over it are limited. What we can explore, though, is if we have evidence that extraordinary damage to the highway is being caused by an extraordinary circumstance, that we can use Section 59 of the highways to secure costs for repairs along that route. But actually, but that needs to be on an evidence basis. But that is implicitly intended to cover extraordinary damage. Okay.
Yeah, I think just to add as well on this, that there is an issue here as well around the level of traffic that uses that country road. As I say, it is an entrance into a relatively small village that's not carrying sort of very large amounts of traffic. Now, that's not to say you won't get conflicts, but we're not talking about a road that's heavily trafficked. It's essentially a road that only provides access into the village. It's not a through route in terms of a route that's used to access other sort of settlements within the sort of Seaton Valley sort of area.
Thank you, Chair.
Councillor Dodds.
Yeah, I'll keep my questions brief. Do we have any other sites in this county that have restrictions like this? Because I recognise 8 o'clock till 6 as the standard working day in sort of areas like this. I mean, in my sort of west of my area, there's a lot of quarries that start at 6 o'clock, so that they're onto sites and roads in time for everybody else's working day. Thank you.
Yeah, I'm not aware of any other sites that have these 9:30 to 4:30 restrictions. As I say, the standard delivery hours are generally the 8 till 6, as are the construction working sort of times, which, as I say, are approved 8 to 6 for this site anyway.
Councillor Hutchinson.
I'm sorry to get back to the enforcement side of things, but have since there been any breaches, even minor breaches, from when the site was first began, has enforcement ever written any correspondence to Barrett's to give them a warning, or are there any logs? Have any logs been kept regarding these alleged breaches, as to the build-up of how many and how often, how frequently?
Yes, information is held by our enforcement officer. As I say, it's not really, it doesn't really help going through figures in detail, because they do vary from week to week. That's what we found, that you might get a period where there is compliance generally throughout a week, and then another week where it's not so good. So it has varied throughout the course of the year. In terms of liaison between our enforcement team and Barrett's, that has largely taken place through this liaison group. The whole purpose in setting up the liaison group was to basically provide, rather than just relying on sort of correspondence, to provide a forum where people can actually sit down obviously virtually, given obviously the current sort of climate, but a forum where all the different parties can sit down and discuss the issues rather than just paperwork going backwards and forwards. And we've generally found that in terms of addressing issues, the liaison group kind of model has worked sort of reasonably sort of well. Yes, that there has been a continuation of the breaches, but I think in part I don't think that's from a want of trying on the part of the developer to try and secure compliance. I think that there are some difficulties, and that obviously we're dealing here with third-party suppliers who obviously aren't directly employed by the developer. So in that respect, for example, it's obviously different to, I often think in terms of delivery routes, you often think of open cast coal mine type schemes that we've had in the county in the past, and obviously with those the situation is that it's often easier to secure compliance because the drivers are actually employed by the company, banks or whoever that company sort of is. Obviously it's a slightly different situation here where you've got third-party suppliers obviously delivering to a developer site. So yes, a lot has been done in terms of liaison with suppliers, but I suppose there's always going to be that increased risk of some non-compliance because you're dealing with a third party, as it were. But yeah, as I say, the liaison group's generally been the point, the mechanism to try and iron out some of the difficulties that we've had.
I'm just very conscious that enforcement hasn't been very good at enforcing things with other things in the past. It's a shame, but just don't seem to have the teeth that they should have. Potentiality of, well, wagons parking before 9:30, waiting to get in the site. What's the potentiality of wagons parking before 8 o'clock, waiting to get in the site? Still causing congestion.
Well, yes, that I acknowledge that's a possibility, and that's something that we would have to again sort of monitor from an enforcement point of view. And if that were to be a problem, then again consideration would have to be given as to whether formal action was justified. I suppose in that sort of scenario, if we were in a situation where more generous delivery hours had been approved than are approved at the moment, then in terms of justifying formal enforcement action, obviously it would be easier for the county council to justify formal enforcement action in terms of breaches in that sort of scenario, because obviously the argument could be put to a magistrate, for example, that, well, we have given Barrett's flexibility around delivery hours, greater flexibility than they had originally, and they're still not complying. So I think we'd obviously have to assess the situation as things develop if that was a situation.
Chair, if I can come in here. It's clear there's lots of concern. It's clear there's lots of concerns about this, and I do feel that Councillor Dodd has made a valid point that it is normally acceptable to align delivery and operation hours, and there is an argument that if this site is worked more efficiently, then the site will be finished quicker and the overall impact will be reduced. Notwithstanding all of that, having heard what the committee's been saying, remember that members are faced not just with a yes-no situation here in terms of supporting this proposal. Members could suggest, for example, that this amendment be put in place for, say, a 12-month period, and we align monitoring over that period to see whether the benefits that are argued by the company are delivered, or whether actually it does actually not address issues, or it does make matters potentially worse. Okay, because at the moment we have some very firmly held views in all directions on this, but we have to look at this application on merit. And Councillor Dodd's point about other sites is, I think, a reasonable one. But having said that, members may wish to consider the amendment to give a, say, 12 or 18-month, whatever period for trial. Yeah.
With your indulgence, Chairman, just one very small question. Very small. I liked your idea, Rob, of highways, being checked and make sure they're okay. I think that's what happened at Tranwell at the open cast, and it was that was amended, and they did fix the highway better than it was before. But have before and after, well, have before photographs been taken to know what it was like before they started the actual?
I will need to talk to our highways teams about the detailed mechanics of this, but you do have reasonable expectations of wear and tear, and you can look at we can look at records because highways are inspected to a schedule.
Yeah, I've just come back on that particular point. That there was some survey work undertaken by our highways team prior to the original planning application for the site, for the housing on the site being decided by strategic planning committee, and that would have been in 2016. Obviously, in terms of the Section 106 agreement that I mentioned, that relates to sort of various kind of road safety kind of mitigation sort of measures. So there was a detailed survey of the entire route between the junction of St Michael's Avenue with the avenue and the junction of the A192 with Double Row to the sort of west of the site, looking at the kind of current highway conditions and what changes could potentially be made. Yeah.
Thank you very much, Chairman.
Thank you. Councillor Ball.
Most of mine's pretty much been covered, but what do we have to lead us to believe that they will adhere to the rules? If we move the time to 8 o'clock in the morning, they won't turn up at 7:30 because if enforcement aren't doing anything about it now, what happens when they start turning up at 7:30, 7:15 and adding to the problems in the area? And also, if we change things, obviously there's already been highlighted the issue around the traffics and lorries coming both ways. Could we not look at better management of the site with regards to the deliveries? Because it's, from what I can see, we're not going to hear of this again until there is an accident or something does happen on that site, and I think it really needs to address now rather than later. Thank you.
Okay, I think to deal with your last question first, which is around kind of management of deliveries. Again, as I say, that's something that could be addressed through some changes to the wording of the condition. If you felt it was as members that there was a need for further work to be undertaken by Barrett's to kind of manage the times when delivery vehicles are coming to the site, so you're trying to minimise conflicts between vehicles on that section of country road. So if you did consider that more work on that was needed, and that was work that you would want council officers to as it were, sign off on and agree the details of, then some wording could be added to the condition around a further addendum to the construction method statement having to be submitted to and agreed by sort of officers around management measures that will be put in place to try and avoid conflicts on the surrounding highway network from delivery sort of vehicles. In terms of the first sort of question around essentially seem to be the point, well, if the delivery hours are extended to allow deliveries from 8, what's the likelihood of deliveries turning up sooner than that? Again, that can't be discounted altogether. As I say, we'd have to obviously assess the situation if that arose. And I think it's a similar response to the response I gave to Councillor Hutchison earlier, that, as I say, we'd have to monitor the situation and see whether that became a problem. But I think my view is that if that did become a problem, then we would be more justified in taking enforcement action, because we'd already given some flexibility on the hours. So the expectation would be, well, you've had that extra sort of hour and a half in the morning. Therefore, there really should be no excuse for arriving earlier than sort of 8 o'clock.
I would just say that it does happen on other sites with an 8 AM start, and we really need to have enforcement to have some teeth about it and really come down on them when they do break the rules before 8 AM.
Thank you. Councillor Flux.
Thank you. I'll try and keep it to questions and I'll keep the debate for later. But I was going to ask, you mentioned about a pedestrian crossing. Well, it was mentioned in one of the speeches. Where are we with that? Is it far off? Is it something that can be front-loaded? Could we front-load it as part of this as a condition here, that they need to get that done rapidly. It's also mentioned about 70 dwellings, and I might be indulging myself a little bit in this second question, but at 70 dwellings, it was said that certain conditions had to be met relating to section 106, I guess probably to section 278 and to other issues as well. Are we ready with fencing, roadblocks to stop any development going above 70 if conditions haven't been met?
Yeah, so in response to that issue about the pedestrian crossing, that's part of the package of works that would be secured through the Section 106 agreement. So the crossing itself is within the village, so it's within the area where delivery vehicles should not be, basically. So as I say, if there's compliance with the condition around delivery vehicle routes, there shouldn't be construction vehicles where that pedestrian crossing would go. As I say, it's secured as part of the Section 106 agreement work. So, as I say, the timescales for the provision of those are very much set by the agreement. As I say, it's they have to be in place, the works have to be completed and in place prior to the occupation of 70 open market dwellings. There are discussions taking place at the moment with our highways sort of team in respect of those works. They're still at quite an early stage, because the money for the works isn't paid across until, well, it's paid across prior to first occupation of the development, and we're just about getting to that point in the very near future. So there are some discussions that have taken place, but there's still a fair amount of work that has to be done in terms of agreeing the detailed specification. I did mention earlier that some work has already been done by our highways team. There is a report that was prepared by our highways technical services team. That was just prior to the planning application going to committee in 2016. So that did look in detail at this whole section of public highway between essentially Seaton Delville and the avenue, so right through the village, Double Row, Bristol Street, St Michael's Avenue, all the way to the avenue, and the measures which are all detailed in the 106 agreement, that would be funded with this £162,000. Those measures are derived from that report that was undertaken by our own technical services sort of team. So there is that work that has been done. So essentially, I think the expectation is that the detailed design work that will be undertaken over the coming months, that would be based on the initial work that was already done back in 2016, which identified the different measures, which included the pedestrian crossing that you've mentioned. So the measures have very much been agreed in terms of what will be put in place. It's just the detailed design of those that needs to be obviously sort of specified, as it were.
Sounds like saying no, we can't.
Well, no, as I say, we are bound by the
Right,
Section
thank
106
you.
agreement.
Any more?
Could I just if I answer a question which hasn't been asked in this direction, but you've all been hinting at it. Right. I've got new hats on at the moment in terms of my function, and I've just been looking at the opportunity. If, say, you were concerned that the hours of delivery were changed and parking outside those areas was starting to take place as well, if we could have objective evidence that the parking of HGVs outside the site was causing a problem, particularly to highway safety, then we could look at potential taking other measures through the Highways Act about it. That would need to go through an order. It would need to be based on evidence. So there are provisions about HGV parking on residential streets. Parking an HGV of over 7.5 tonnes isn't in itself, but we can take steps if it is causing a demonstrable problem. Okay, I'm not saying it is. I'm not jumping to the conclusion that it is causing a problem, but we could look at that issue. Okay. Thanks.
Thank you, Councillor Swinbank.
Thank you, Chair. Just quickly, Jeff, if obviously one of the main concerns from the objectors was with regard to safe walking routes to school, I think it's fair to say. Could you take us back to the kind of master plan slide and just show us which routes the deliveries are meant to come down? And obviously, because within the wording that you've given us for the condition just today, you've mentioned certain streets that are excluded. Can you kind of show us where the school is, which streets will be excluded, and where the vehicles should actually go if they follow the conditions?
From kind of Monkseaton, Shiremoor, on the A192, or from if you're coming in from the west on the A190 through Seg Hill. Then again, the traffic is directed to either go straight ahead or turn right into the avenue and take the grade route. Likewise, if you're coming from Seaton Sluice, so the coast is over here. Basically, you're coming past Seaton Delver Hall. On the avenue, again, the signage directs you to turn right and come into the site, so that way. So essentially, in a situation where there's compliance with the delivery route, there shouldn't be any construction traffic at all on Double Row or on Bristol Street or on this part of St Michael's Avenue to the immediate west of the site. The majority of the village itself is west of the application site. So between, as I say, where you've got the application site here, this is the level crossing on the Northumberland sort of line. There's not a large amount of, there are some houses on the opposite side of St Michael's Avenue, and one or two small properties adjacent to the level crossing. But in the main, the majority of housing in the village is west of the site. So the construction vehicle route is designed, as I say, to minimise the impact on residents. So yes, in terms of children going to school, as I say, the primary school primarily serves children within the sort of village. So the majority of those will be walking to the primary school along sort of roads that should not have construction vehicles on them. In terms of the development itself, initially those who will be living on the development will have to use St Michael's Avenue to access the roads to the school. As the site becomes developed, there will be a further access at the northern end of the site, which connects in here. So this is an existing housing estate to the immediate west of the site. So there will be another route to the school from the north of the site, but obviously that will only come on stream as houses get built. Essentially, in terms of the actual build programme, they've essentially started at the St Michael's Avenue end of the site, the southern end of the site, and are working their way kind of northwards. So that's, as I say, other schools were mentioned. There is a middle school in Seaton Sluice. My understanding is that the majority of children who are going from the village to the middle school in Seaton Sluice will be either getting driven there by sort of parents, or there are school bus services as well which serve the village and take those children to Seaton Sluice Middle. So that's certainly my understanding. As I say, my own son actually went to Seaton Sluice Middle School, and he would get the school bus sort of every day from where we sort of live. So in terms of there is another middle school in Seaton Dalville, but again, my understanding is that the majority of children in New Hartley will not go to the middle school in Seaton Dalville, because the catchment school is Seaton Sluice sort of middle school. You've got the high school, Applicant High School in Seaton Dalville, which is essentially this area. So again, in terms of travelling from the village to the high school, most of that traffic will be via the Street and Double Row into Seaton Dalville. It won't generally use this particular sort of route where the construction traffic sort of is. That's a summary of the situation. Thank you,
Right, members, any other questions? Can't see any. I think I've done that one. Right, debate. Now we're going to open the debate with a proposal, and you've got plenty of things being offered, whether it's temporary, whether it's full, whether it's for or against. So it's up to you, Councillor Hutchinson.
Could I propose the officer's recommendation with the added condition that Rob mentioned? It's for 1 year, and see how it goes with it being monitored, with the potentiality of renewing the application after a year.
That's one. Do we have to debate this one before we can move on to any others?
You need somebody to second the proposal.
I know I've got other hands up, you see. So they might want to second that, they might want to propose another motion.
If it's seconded, we would then go on to the debate.
Right, so we've got it proposed by Councillor Hutchinson, the officer's recommendation with the added thing of a 12-month review.
Should I read out the formal proposal,
Yes,
just to make sure that that's what everybody's happy with? So it would be to grant the permission as set out in the papers, with condition 15 as set out by the officer as the wording given in the committee, to be in place for 12 months.
Everybody understand
Is
that one?
correct? And that was the proposal that was seconded by you, Councillor Stewart.
Yeah.
Thank you.
So I'll open that up for debate. Councillor Flux.
Yeah, thank you. I'd like to start the debate because I don't actually know I'm going to vote yet. This whole thing just seems to me to be, a dog's breakfast, frankly. Why the hell was it not, considered when as people sitting in appeals rooms about the hours is beyond me, absolutely beyond me. Why we've got stuff about what Ian Levy does in Parliament and why the committee should take notice of, he's doing his job down. What the hell does, is what he's doing on that committee, whether someone starts at 9:30 or 8 o'clock? Of course it's not. I mean, it's absolutely daft, and it's quite insulting to this committee that was even put in, to be perfectly honest. So from my point of view, what I don't want to see is, us lose again something. So if we can get half a loaf rather than no loaf at all, maybe that is the way to go. But I really, if I do support this, it would be with the heaviest heart I've ever supported an application, because of It's infuriated me, the whole thing. I'll be perfectly honest. Thank you, Chair.
Thank you, councillor. Any more? Councillor Dodds?
Yeah, I was on the committee when 2016 when this was a game of tennis, and it was like a very bad game of tennis. We went against officer recommendation in the first place on this one. It went to appeal. We lost. I think it cost us a fair bit of money. We still seem to be making a dog's breakfast of all of this. Now, you know, I think, you know, if it went against and the applicant went to appeal, we would again lose. There is a set time where we have to come in and come out of sites. Sites are always awkward. There's always two sides to every story. I get that. I go back to a Pontiel and Rialto's, Fratelli's and the Sainsbury's supermarket, and the restrictions were put on. A 7.5 ton wagon was the limit. No more than 20-foot long wagons. Castle Morpeth had officers there 2 days a week, full time. It cost an absolute fortune. Objectors were there with their tape measures, measuring every wagon. If they could weigh them, they would do so. We seem to get ourselves into some serious knots. Let's get this development has gone through. We lost at appeal. Let's get it done and dusted. Let's get the money that they have to promise to put the roads right and roundabout and get it done. The battle for this has been lost. We need to get on and finish the job that has been done. Thank you, Chair.
Thank you, councillor. Anybody else? Councillor Hill.
I can't support this, and one thing I would say is, and I've seen similar things happen before when you've had this battle and developers, you know, give an inch, take a mile, and enforcement. And I know there are procedures and everything, so it's not as easy. But I think we could do more and have more teeth in it. But I can see this just getting worse and taking more and starting early. And I think that we should, forefront of my mind is residents' amenity and highway safety. I know I have to make my own mind up on it, and the simple fact is more vehicles, more larger vehicles, at times schools nearby and school children is by definition a highway safety issue. And I think that we should stick to our guns, say this is the condition, and you stick to it. And if you need to work later or faster or do whatever you do to get the built, then do it. But I don't think we should kowtow to these people.
Thank you, councillor Wallace.
Yeah, thanks, Chairman. Mr. Horseman pointed out those two things to look at. One was for the residents, which I firmly believe we should. Any new planning application should always take cognizance of how it affects people who live there, perhaps for generations. And I can understand the objections today. I can understand the objections from the past. The second point Mr. Horseman said was about highways. Dr. Bunn pointed out there'd be no additional vehicles coming into that village in a working day. In fact, what would happen, it would reduce congestion. I did not hear in almost 1 hour, 30 minutes of this discussion, Chairman, anybody mention any accidents that's happened in and around the school or St. Michael's Avenue. What I do know is, if you live in a new housing estate, you really live on a building site. And if you live on a new housing site, you want that building to be finished as quickly as possible. Let's get the Section 106 monies, let's get the houses built, and let's get barracks elsewhere and bring New Hartley back to a peaceful community. Thank you, Chair.
Thank you. Councillor Darwin.
Thank you, Chair. I've heard some of the discussions, and I understand that residents have anguish about the vehicles travelling through their village, but I live on a building site currently. That building site operates from 8 AM till 6 PM. And if that building site operated at 9:30, you would have wagons there parked up horrendously until they were allowed on site at 9:30. It works well from 8 till 6 PM. The idea that these lorries will get earlier and earlier, in my mind, is a little bit far-fetched. hauliages start at a set time. They do not open earlier and earlier because the building site opens earlier and earlier. They will get there on site at 8 o'clock, they will get into site for them to start their work. This condition is, in my mind, making vehicles park up on the highways before they can get admitted onto site at 9:30. As has been said, we should allow these vehicles in earlier, get Barratt homes built, get them off site quicker, and allow Barratt to move on to another site. We need these houses built. It is with a heavy heart that I think we have to go against. We're going to bring it forward after it has been agreed. It was 8 a.m. till 4:30. But I think this is the right thing to do. It should be normal working hours, and it gets the vehicles inside, gets the houses built, because you will have workers on site doing little until the vehicles turn up. So I think I'm in favour of this as proposal by Councillor Ian Hutchinson. Thank you, Chair.
Fine, just one small point. It's 8 till 6, not 4:30.
Yeah, the one currently is 9:30 till 4, so that's what I was saying. So I think it should be allowed 8 a.m. till 6 p.m. That doesn't mean you'll have more vehicles coming in the morning, more vehicles in the afternoon. The site working hours is I think should be at every other site in Northumberland.
Thank you. Any more want to join in? Councillor Hutchinson?
This will bring it to a close, mind.
Do you want to wind it up? Yeah.
Right. Yeah, I regret to say this, but I agree totally with what Councillor Dodd said. What swung me was most sites are open from 8 till 6. And the other thing that I appreciate was Rob's intervention, saying that it could be for a year, which I hope will allow the residents to have peace of mind that it will be monitored for a year, and enforcement will monitor it, and they will monitor it. And if there is something goes wrong, heaven forbid, but if it does go wrong, enforcement will enforce for a change. Thank you.
Right, we've heard the motion. All those in favour? 4.
Eight, 4.
All those against? 4.
4.
And was there any abstention?
No.
Councillor Flux. That's the motion carried then.
Chair, if you don't mind, can I give due notice? I'll leave about 6:05 to attend a parish meeting. I missed the last one. It's the first one I've missed in excess of 12 years. I believe it's important that as county councillors, we also work in partnership with the parishes. So I do apologise, I have to leave.
It's fine, Councillor Wallace. We'll see where your loyalty lies. Right, let's get back onto the original agenda. So the next application we'll hear is the variation of condition 5, restoration of approved planning application 13/01492/VAR-CCM in order to allow for the restoration of the site to be completed as amended on the 26th of February 2021, 16th of June 2021, Halton Lea Farm, Brampton, Northumberland. Who's taking that one? Right, Catherine, carry on.
Thank you, Chair. As Councillor Roberts has just said, this application is for the variation of condition 5 of the planning permission that was granted for the open cast site at Halton Lea Gate, at Halton Lea Farm at Halton Lea Gate. Just by way of quick update, just something to point out on the report has got the wrong date on the top header of the report. It's for last month. It was omitted to update it to this month. So just as a point of reference that we're considering this application at the October meeting and not the September meeting. The other point is that the section 106 community contribution has now been agreed. We were still in negotiations when I was writing the report. And the community contribution has been confirmed will be £30,474. Okay, so this is a site that was granted planning permission in 2011 on appeal for the open cast working It's located at Halton Lea Gate, which is right on the most western border boundary of the county. The black dotted line is the border between Cumbria and Northumberland, to give you a bit of an idea of context in terms of how far west it is. It was granted planning permission in 2011, and it's been since worked as an open cast site. The operators went into administration in April 2020. And since that time, Rob and I have been negotiating very hard to get a positive outcome for this site, because at the point in time that they went into administration, the site was very much an open cast site. We managed to agree with the administrators that they would use the restoration bond, which was provided by the funders, which was an American company called XWorks, as a budget for their restoration. And I'll just give you some idea of what the site. This is the aerial photograph of the site before it was open casted, and this is an aerial photograph that was taken during the course of the coal extraction, to give you a flavour of how much in the site was mined. This is the revised restoration plan that we're wanting to be considered. It's basically the previous restoration plan was taking the site back to agriculture, sort of grazing land. This is more of a nature conservation approach with open land seeded to a nature conservation seed mix, with the blue areas, darker blue areas, scrapes for wading birds. This has been negotiated with our ecologist, who was very much in favour of taking this site back to being more of having more of a nature conservation bent on it, but really is in response to just ensuring that this site is restored and wasn't left as a open cast site without any restoration. So just to give you an idea of where we kind of were when the site went into administration, which this photograph was on the far side was taken in March 2021, but in the intervening year there wasn't really much happened on the site. We were very much in negotiations, and the site sat still. So you can see that there was still a void there, still lagoons and soil not replaced, and the photograph on the other side shows the restored site. And again here the lagoons still in evidence in March 2021, and the site restored in September 21. And just these are most recent photographs that taken when I've been going out to monitor the site restoration, showing the soil back in and the site seeded. Sorry. I have actually got, I don't know whether I can show them or not, some drone footage of the site. I don't know whether you want to see that that the operator's given me. I don't know whether I can do this or not.
I did ask Catherine, everybody said they had seen it.
Have you? Okay, sorry, it's been circulated. Right, okay, I won't show it again then. Okay, so the restoration's now complete, and as you can see from those photographs, so the main issues for consideration are whether that restoration plan is appropriate for the site, bearing in mind that the operators have gone into administration, and we could have been left with a situation where we were left to enforce the restoration of the site through the restoration bond. The recommendation is to approve subject to Section 106 agreement, which removes the conditions, removes the previous obligations in respect of vehicle movements and the community liaison, and replaces the Section 39 agreement for the long-term management of the site for 30 years, and also the community contribution in lieu of the previous community fund, which would be payable 14 days post granting of planning permission. So within the next 14 days, assuming that you agree to this this recommendation, that we would get the £30,000 for the community.
Thank you. We've got no speakers on this one, so straight into members' questions. Any members got questions on this one? No. Oh. Councillor Swinburne.
Thank you, Chair. I was just wondering whether Catherine or Rob could take us through kind of, obviously it was left as an upcast site administration. What actually happened after that? Just take us through what happened.
Yeah, okay, yeah.
If you will, this represented the worst possible case scenario in doing minerals planning. Okay. The worst possible thing to happen in terms of a open cast coal site is for all the coal to be taken out, and then on the worst possible day, the operator vanish or go bust. That is why you ask for some form of guarantee the work will be done. We requested, and it is good practice to request, that they deposit the money in our bank account. What was done here was that the American funder behind this offered a restoration bond for it. So this wasn't like dealing with banks, say mining, who are a British company, who have multiple sites and land assets. This was dealing with a situation that Catherine and I were faced, where the firm had got into liquidation. The restoration was going to cost between, £400,000 and £800,000. But at that time, the company had debts of more than £9 million, and we weren't a secured debtor at that point. So the situation could have been, if we'd have gone in and said we should take enforcement action, so you've got to do it, they would have just walked away from the site, an American company, because the land isn't worth £9 million. So there's no actual inducement for them to sort this out, apart from what we could leave her in. So with all those in mind, what we did, we looked at a restoration scheme that would tackle the problems on the site, because the operator had done other things as well. And the operator, as a separate context, the operator has been tracked, that person who operated has been tracked down, and they are being prosecuted now in the Crown Court by the Environment Agency. That is separate. But they'll have had no assets. So what we looked at is rescuing this site and actually saying, now we have the opportunity to direct what's happening here, what would we want out of it? So rather than looking for a mediocre to poor quality agricultural reinstatement, we look at what would be a currently good practice biodiversity-led restoration, and including what Catherine got them to agree as well was a 30-year maintenance period on the land. At the start of this process, there was also a community bond as part of the 106 that we couldn't enforce against, because there were no assets left. That would have been really down the list of the people creditors. But what we did, we said to them, if we can work jointly with the American backing company, get a scheme on here which meets everyone's requirement, let's have an open book approach. So you give us the bills you are paying. So it isn't just you saying you've spent this much. Let's see what you've been paying. And if there's anything left after the restoration underwriting, let's give that to community. They offered £20,000 as a once and for all settlement, but we went down this route and we got, so I do like the way that we've got it down to the nearest pound, but it's to say £30,474 for the community, and the scheme is restored. And as well, what we've also got, there's a bit of the site which doesn't make particular sense in terms of this overall ecological restoration. So the liquidators have offered to give that to the parish council if they wanted. And there's been some objection about it, say, being potentially used for allotments from some residents. But just to be clear, if the parish council wanted it, they could have it. But if they wanted to do something with it, that would probably require planning permission. So that could be handled separately. So we think that the package, and it was a monumental task to turn this one round. And there were several days in the negotiations where they were ready to walk. So I think it's a great success for Catherine to have sorted this one out. 'Cause it is the ultimate worst case scenario for a minerals application. So it's not one of our making at all. The Americans were very clear that their decision to fund this was probably worth revisiting. So we are where we are, but I think we have pulled it back from the precipice on this one. So this is a case of just tidying everything up. Now we've got a final restoration plan, and that restoration will be followed up by 30 years of aftercare to make sure that the ecology is well established.
Thank you. Councillor Wallace?
Thanks, Chair. Thanks for that information as well, Rob. My question is specifically on Hartley Parish Council. With a precept of £2,900 per annum,
Yep.
what do you see them doing with community land that can delay the implementation of a condition number 7 for a further 12 months? What I'm trying to say to you is, are you having dialogue with them now? Can they give you some indication to restore this site immediately?
Okay, that part of the site was never open casted. That's just it was actually just on the edge of the site. That's the sort of virgin land, if you like. So it's not, doesn't need to be restored. The gift of the land to the community wasn't necessary as part of the planning permission. So we've left that as negotiations between the administrators direct and the parish, and so we've effectively given them 12 months to decide whether or not they want to take it or not. If they don't take it, then it would just be incorporated back into the site.
Thanks for a full explanation, but it just seems as if it delays it. I can't see a parish with a precept of £2,700, which probably only covers 12 meetings a year, if the reality's known, wanting to do anything with that land.
Yeah, Chair. It was a piece of land that was left over from the restoration, and clearly the American company behind this don't want to own one small corner of the site, which is of no development value to them. And Catherine suggested they offer it first to the parish, because the parish may want it for holding, events on, whatever. It could have potential for allotments, again, but that would require planning permission.
Thank you. Any more questions? Okay, let's go to debate. Have we got a proposer? Councillor
I'm going
Hutchinson?
straight in. It gives me great pleasure to propose this plan, the officer recommendation. And could I just say thank you very much to Rob and for Catherine for all the unseen work that none of you lot knows done.
Yep.
I'm the ward member for there, and as I said before, this has gone on 10 years. The locals have gone through hell. You've gone through hell. I've gone through hell. So I'm really pleased that this is coming, hopefully, to an end. Thank you very much, and I propose this officer recommendation.
Thank you. Seconder? Councillor Flux.
Thank you.
Do we need a debate? I'm looking. No. Do you want to wind up then, Councillor Hutchinson?
I've more or less said it now. We'll save time. We're nearly up to 3 hours, so we'll keep bashing on, but thank you again very, very much.
Looks like a simple one, this one. All those in favour? Unanimous. Right, thank you for that. Before we go on to the next one, anybody want a 5-minute recess? No? Bash on. Here we go then. Councillor Wallace, if you're leaving. Right. The next one is application of outline plan permission with some matters reserved for construction of residential development up to 500 dwellings, including affordable homes, public open space, access to an existing highway and associated works, land south and southeast of Jim's Calvert, Spence College, Acklington Road, Amble. And I can't quite make out the number. 1604305 stroke out. And who's doing this one? Neil? Is that you?
Yeah, Chair, thank you very much. Firstly, just want to refer to an update before just quickly running through a few slides and a brief summary, and that's a late representation from Amble Town Council. So the Town Council referred to their previous comments, which continue to be held, but due to the number of dwellings proposed, strongly recommended that the infrastructure areas stated in the August 2017 committee report are applied. And in this respect, the Town Council refers specifically to paragraph 7.70 of the original August 2017 report, where reference is made to contributions for affordable housing and ecological mitigation, as well as contributions in respect of off-site sport, recreation provision, education infrastructure, primary healthcare and highway works. And the Town Council also referred to paragraph 7.73 of that report, which refers to consultation with the Town Council to advise on specific areas, projects where contributions in relation to sport, recreation, leisure are required. And the Town Council would urge these consultations are commenced again with urgency. And in summary, the Town Council believes that if 500 more homes are to be built, then additional recreational facilities, healthcare cover, which should also cover dentists, are needed in Amble. So the application seeks outline permission with all matters reserved other than access for the construction of up to 500 dwellings on land adjacent to the James Calvert Spence College to the west of Amble. As set out in the addendum report, there have been 2 existing resolutions to approve development on the site from the Strategic Planning Committee. The Section 106 agreement has not yet been completed, and therefore the decision notice has not been issued. The application is therefore being brought back for consideration to update members on changes to the National Planning Policy Framework, as well as referencing the emerging Northumberland local plan position. And the report also seeks to consider a change to one of the highways conditions and a related amendment to the Section 106 planning obligation requirements. Just quickly run through a few of the slides just as background, just to highlight the location of the site. You can see the extent of that to the southwestern edge of the town. Since that application was first in, we've also had other applications for major development within the town to the very western edge, just to the northwest of the application site, and also to the eastern edge of the site as well, approved as an outline application. This is just a plan just taken from the original design and access statement, just showing the location of the site there to the bottom left in red. And the blue routes there, the blue arrows, are the main B road on Acklington Road there, and then running north to south, the route of the A1068. But just to give an idea in relation to the rest of the town, and a closer image of the site itself, and not shown on the location plan, but you can see there just to the northeastern boundary there, to the top right, is the adjacent Persimmon development, which was well underway at the time of the application originally being determined. This is just plans that were submitted with the application, just to show potential connectivity, but also the indicative layout there. So yeah, so just an indicative layout plan there. So all matters of other than the access are reserved. So layout, scale, appearance, and landscaping would be reserved matters and dealt with as a future application. But discussions, as referenced in the original report, they're about incorporating larger areas of green open space for ecological purposes and for just overall landscaping of the sites. So the indicative plan taking that into account with the larger green open space to the southern boundary there. So the original committee report from September 2017 assessed in detail the impacts arising from the proposal, including whether this would deliver sustainable development, having regard to economic, social and environmental objectives. Following publication of an updated version of the MPPF in July 2018 and the addendum report that was presented to the Strategic Planning Committee in December 2018, it remained officer opinion that the proposals would be acceptable on the basis of the development plan and other material considerations, including the MPPF. So the most recent changes to the NPPF in July 2021 have been considered in the context of the previous assessment of the application and the resolutions from the committee, and it's also not considered that there will be any material change in that original assessment or conclusions of the officer report. The proposed development is still considered to achieve a sustainable form of development that would be in accordance with the relevant development plan policies and the revised MPPF. The proposal is also considered to be in line with the emerging Northumberland local plan, whilst further consideration will be given to detailed matters such as layout, scale, design and landscaping at that reserve matters stage. Subject to conditions and appropriate mitigation as necessary, and including the proposed amendment to Highways Condition 13 that's set out in the current report, the proposal is also considered to be acceptable in respect of other matters such as transport and highway safety, flood risk and drainage, ecology and ground conditions. The identified planning obligations will still need to be secured through the Section 106 agreement, and the proposal is therefore considered to result in an acceptable and sustainable form of development in this location, having regard to the development plan and the MPPF. So just to summarise the updated recommendation just from the latest addendum report, it's recommended that members grant permission subject to the conditions as specified in the report to the Strategic Planning Committee in 2017, with amendment to Condition 13 as set out in the current addendum report, and the completion of a Section 106 legal agreement to secure 15% affordable housing, education contribution, healthcare contribution, sport and play contribution, provision of ecological mitigation and footpath cycleway connectivity. Thank you, Chair.
Thank you. Public speaking now. I haven't got your list, Councillor Watson. No, good. I have Chris Martin. Chris, you've got 5 minutes.
Thank you, Chair. My name's Chris Martin from Pegasus Group. I'm here today on behalf of the applicant to speak in favour of these proposals. Members will be aware that the proposals have received 2 previous resolutions to grant outline planning permission, subject to the completion of the Section 106 agreement. The committee report outlines the reasons to why a fresh resolution is now needed for the proposals, and ultimately concludes that the scheme still accords with the current development plan and relevant material considerations. We endorse this position as the principle of development has already been established and continues to be acceptable. We've worked closely with the Council's Planning and Highways team to ensure that the scheme will be able to be delivered. In this respect, pending a positive resolution today, the Section 106 will be finalised so that the outline planning permission can be issued. It is then intended that the reserve matters will follow shortly thereafter. The Section 106 will secure affordable housing, contribute to off-site sports provision, as well as education and healthcare. And the proposals will allow for the future cycle and pedestrian link to local highway routes to further improve connectivity. The site itself lies within the proposed settlement boundary of Amble in the emerging local plan and forms an identified housing commitment as a minded to approve site. The site therefore makes the key components of ensuring that the council is able to maintain a supply of housing land over the plan period, and it broadly reflects the requirements of draft policy STP1 and policy HOU2 of the emerging local plan, which sets the minimum housing requirement for the county over the plan period. We consider that the proposals continue to represent a sustainable addition to Amble, which will help the settlement achieve future growth and will benefit the local economy in terms of job creation and increased expenditure in the area. We therefore put to members that a fresh positive resolution to grant planning permission should be given to allow the site's delivery. Thank you very much.
Thank you. Right, committee members' questions to the officer. Councillor Hill.
Thank you. Just to say it's really good to see a really robust and meaningful list of Section 106 on this. So that's good to see. Can I just ask, and I think it's a point that Town Council have raised, and it comes up from time to actually most of the time when affordable housing is raised. How watertight is the commitment for the delivery of affordable housing, and what is the makeup? Is it really affordable housing? Could you just tell us a bit more that this is going to in short, is it going to deliver affordable housing?
Yep, thank you, Chair. Councillor Hill. Yeah, so the affordable housing provision, as with most sites where we're securing that on major developments, will be secured through the Section 106. And that's been a commitment all the way through from the applicant and going forward in these current discussions. So as ever with that, we'll apply that 15% across the site in line with the previous recommendations. The Section 106 will make that clear in terms of the various clauses. We get a lot of input into that from the affordable housing team as well. So in terms of the type of tenure, type of housing, so we can set out there in terms of the extent of social rented housing, the affordable rented, or for other ownership options such as discount market value or the shared ownership options. So that's will be agreed as part of the Section 106. Obviously, what we don't know at this stage is the exact housing mix, but that will need to come forward through the various phases, and so that will be secured as a legal agreement through the Section 106. The affordable housing officers will have in mind other sites within the town, what that mix is, what the commitments already are. So if there is a need, maybe to look at different tenures to make sure that the mix is what is required and the house types are what is required, that will come forward through discussions on the reserve matters as well.
And just do we know where the affordable housing would be, or would I hazard a guess that it would be away from the nice green bit and more in the corner? Do we not know that?
Yeah, can I come on this one? Government has actually produced some useful clarification on affordable housing, notwithstanding the fact that government's advice on affordable housing changes all the time, and that's why we never fix it at the point of the outline. We look at how we respond, to current policy and evidence. A useful way of looking at this, though, is that government now talk a lot about things like the First Homes agenda, which is their new approach to doing affordable property ownership. And that's just like the latest version of their approach to this issue. But usually what it says in it, though, is really clear, and it's something that we've been trying to encourage, is that the design should be tenure blind. In other words, you shouldn't be able to differentiate between those houses which are affordable and those which are intended for open market sale. And that's particularly important when you're talking about the first home. So they should be pepper potted through it, and particularly the design shouldn't be of a lower quality or space provision or standard than the market ones. Okay. Thanks. To try and cut this one as short as possible debate on this, I can answer another question about 106 as well, just to be clear here, and we've got a local rep in here. At the time we granted the first permission, the issue came up, which always comes up in Section 106s, and that's how can the local community input into what it comes out of it. And at the time we made the first decision on this, we were still faced with the spectre of what are called the pooling restrictions, which means that you have to be fairly precise about what you're going to spend your money on. It's going to be self-contained. Now we have some more flexibility, so the sport and recreation contribution can be focused on what the town council identifies and what meets their local requirements at the time, and we will engage with the town council in them selecting what the money is spent on. So there's more flexibility on that side of it. Okay.
Thank you. Any more questions, Councillor Hutchinson?
Got to make a proposal. We
Well-
suspend standing orders. It's now 6 o'clock. Oh, hell, of course, sorry, my apologies. It seems like it's been a long day.
Just seems that way.
The clocks go back at the end of the month.
No, we'll have to. Any more questions? I would just, I've been good on tonight's agenda, and I would just like to say on Councillor Hill's question there, I think it's a definition of affordable. That really worries me, because they're anything but unless you take local salaries into consideration. But that's completely irrelevant in the course of this. So, if there's no more questions, we'll go to debate. Can we have a proposal? Councillor Flux?
Propose approval, Chair.
Seconder? Councillor Dodds? We've got a proposal and seconder. Any debate on this one? My God, we're shifting on this one. Okay, all those for? Unanimous again. Of all those present. Well, thank you for that. Carrying on with the last of the agenda then. Couple of items to mention. There's an appeals update in your pack and a 106 agreements update in your pack, just to acknowledge. Can we acknowledge those? Thank you. Any urgent business? Well, that's it. Thank you very much, ladies and gentlemen.